the blue go live button. And we're live. It is Tuesday, March 23rd, 5:02 p.m. Of course, the blue live button has worked perfectly for me because I am running the show today and not Ben. But Ben is happily ensconced in the bamboo studio with some scotch, and in lieu of fun,
just kicking back and relaxing in a chaise lounge by the fire, not running the show. He is peaceful, content for the blue go live button to behave well for Kate in a way that it does not for him. Life is good.
Yeah, Jamal, the thing that you should know here is that for like 340 days, Ben ran all of the back end of the show every single day, and then has only recently kind of given me the keys to the back end of the show. And the vibe, in case you're missing it, is very much of like teenage daughter getting taught how to drive by very nervous father kind of vibe. So, but we do not have fun anymore. But in lieu of fun, we have Jamal Greene. Thank you so much for coming on today, Jamal.
It's my pleasure. Thanks for having me.
Yeah. So Jamal is hold on, Ben. Did you want to say something?
I just wanted to say welcome back to the show. I am for keeping myself muted, which Jamal and Kate already know, but the rest of people don't because there's traffic noise out here in the bamboo studio. So don't mind me if I just am in all every now and then.
Ben, why don't you just let me do it? Because it's not always that bad. Like right now, it's not too bad. So I can just like keep you muted if it gets loud.
All right.
So, yeah.
Sounds
now
good.
It's like bird song.
I sort of like the ambiance of
yes, exactly.
Birds chirping, the sun is shining.
It's Washington in the summer.
Right.
So Jamal has been here before. He was here shortly after the Oversight Board launch, but not here in that capacity today. He is here as a Columbia Law professor and an author of a new book. Let me see if I'm going. Now I just said it. How Rights Went Wrong. And I already put it in the chat, so now they won't let me do it again. How Rights Went Wrong. I put it in the chat before, and you can, there it is. You can order it now. But we unfortunately had a snafu with getting the introduction of the book so that Ben and I could kind of peruse this today. So we're just going to kind of, get started with Jamal just kind of laying out what the book is about, who's the audience, kind of like what compelled you to kind of start this project, all of that.
Sure. So the book, in a nutshell, is about the confrontation between rights, and particularly rights as recognized by courts, and pluralism. And I think that those have to go together in a pluralistic society, but they don't really go together in the way in which U.S. courts and also I think many U.S. citizens frame rights discourse. So we tend to think of rights as presumptively absolute. We tend to think of rights as antagonistic to government, so that governments don't pursue rights; they crush them. Right? That's what they're about. And I'm trying to figure out ways of talking about rights so that we bring those things back together. That rights are what government is trying to pursue. And what's the role what's the role of courts within a society in which we have rights conflicts in every imaginable interaction with one another? The bottom line for me is that we should think of rights, at least when they're decided by legal decision makers, we should think of rights as more capacious, meaning there should be more of them. We should be more willing to understand people's commitments as rights, but that we should be much less absolutist about them and should be focused on the kinds of questions you have to answer when you're resolving a conflict in which there are rights on both sides of the conflict, which are much more retail questions rather than wholesale questions of which person has the right or not. And I could give lots of examples, but that's the abstract.
So give 2 examples to get us started. Bring it down to earth.
Sure. So one example, Citizens United is one example, which is something that many will have some familiarity with as a case in which an ideological nonprofit is trying to put out a movie on video on demand about Hillary Clinton. This runs afoul of the federal campaign finance laws, which say you're not supposed to, if you're using corporate treasury funds, you're not supposed to electioneer within 30 days of a primary election. And this gets to the Supreme Court. The discourse in the opinion itself, which ends up being written by Anthony Kennedy, and in the larger culture, which, this case is mentioned at the State of the Union address, is free speech is on one side of this dispute. And then there's some law that's trying to sort of interfere with free speech on the other side of this dispute. And so the question is really, should we think about corporate interests as having free speech rights? And liberals and conservatives line up reliably on one side or the other of that question. There's a kind of subtext of there's a kind of political equality that the government is trying to pursue here. But the court says, that's just totally not even a legitimate thing to talk about in a case like this. This is
what political equality? Yeah, right.
So the equality is citizens' ability to influence the political process.
It's framed as simply free speech of the corporate entity versus government power.
Yeah.
Right, exactly. And so we line up reliably on one side or the other of that. And, if you ask me, which side of that are you going to line up on? Well, if it's in those abstract terms, I'm probably going to pick, in this, I'm going to say the government's really trying to, go for political equality here. So I don't corporate speech is not that important. And people who are right of center are going to line up on the other side, right? So when the kinds of questions and the case itself, Justice Kennedy renders it in just that way. The whole opinion is about the importance of political speech. And so we're gonna disagree about a case like that. What frustrates me, and this is just one example, of course. What frustrates me is, what are the kinds of questions that one should ask if you're really someone who believes both in the value of free speech and in the value of citizen access to influencing elections on roughly equal terms. I might want to know, for example, what kind of corporation is this? Is this an advocacy group, which Citizens United is, or is this something selling, a widget selling company of some kind? What are they trying to do?
In fact, is it an advocacy group set up specifically in order to create a material to trigger a Supreme Court case on this issue?
Well, Citizens United still exists, right? And they still do advocacy.
I was just going to say that
is a form of advocacy, right? So, in any event, I'm not suggesting how it should come out necessarily, although I have some instincts about that. It's to say, are they putting out commercials, or is it video on demand, which is what it was? What's the burden of setting up a separate political action committee, which is what they could have done if they had wanted to legally put out this movie? I don't know what the burden on them was. I still don't know. I teach election law. I still don't know how burdensome it would have been for them to set up a political action committee. It just wasn't even asked in the case, as if it's not relevant to the question. And so what I'm trying to suggest is that these back-end questions of what do you do, what does a right give you, are the questions that courts and the rest of us should be focused on, rather than questions of who has what rights, which don't help us very much to answer difficult questions and generate more consensus. I could get behind Citizens United getting an exception from the campaign finance laws, given who it is. I can't get behind the broader proposition that corporate speech rights are always more important than whatever the government may want to do in respect to equality.
Okay, a couple of questions. So when you said you were going to give us some examples, so now we have this this.
That was a long-winded example.
No, this is perfect. This is really great because I have a ton of questions. And I don't know. There's always been a part of me that's never wanted to teach First Amendment law ever, because I think you're kind of articulating to a large extent is just like that I simply don't have an intuition about where I myself would feel about some of these. Like, I can draw these kind of fact to fact comparisons, but the court doesn't. And so there are various types of understandings that I do not think are very clean. And so this is a great example. So what I wanted to say is, like, you're talking about what type of corporation Citizens United is, the purpose for it. It's not a widget company, it's this type of company. But those seem like very fact specific, non-Supreme Court level types of types of questions, right? So like, what would the rule come out like if the court had decided? What would be the rule around, like, how would knowing all of the things you know, and how do you stop, like, when does the list run out of things? Like, how is what you're basically creating not some giant like multi-factor test that ends up in like a reasonable, like kind of a reasonableness standard or something around rights?
Well, I don't know that that's a bad thing, right? So you say, what's the rule? It doesn't have to be a rule necessarily, or if it is a rule, it can be a rule at a great level of specificity, right? The rule is, let's say you come out, and by the way, there's some evidence that John Roberts wanted to come out somewhat this way in Citizens United itself. The rule could be an ideological corporation that is putting out an ad in ways that do not involve a captive audience. Must be allowed. I mean, again, I'd have to know more about separate political action committees versus general treasury funds before I could craft the rule, but the rule can be quite specific. You say it's not a Supreme Court kind of thing, and that's kind of the problem, is that the court understands itself as a declarer of rights instead of understanding itself as a resolver of disputes, a solver of problems in which rights are relevant, but are not what the problem is, right? We confuse the question in the case with the legal superstructure that we've created to solve the case. We pretend that the case is about strict scrutiny, when that's just a legal abstraction.
Oh my gosh.
The case is about a company that wants to put out an ad.
I love it. I think I'm going to love your book.
So give us, I have a million questions about this, but give us your second example as a way of winnowing the field.
So I should figure out what that is, because should I stay in the free speech space or should I go somewhere else? So I'll go somewhere.
No, go somewhere else, just so that we have a sense of the diversity of the argument.
I'm imagining you couldn't possibly write this book and not touch on the Second Amendment. So
well, I don't touch that much on the Second Amendment, actually, because in some ways I think the Second Amendment is, I think it's obvious that the way in which we frame the Second Amendment is sort of bizarre and Manichaean, right? That, but very quickly on the Second Amendment, just read Breyer's dissent in District of Columbia versus Heller, and you get where I would like the discourse to be. Breyer's dissent in that case doesn't get into the back and forth about the original understanding of the right to bear arms. He says, well, okay, let's concede that for sake of argument and ask what is DC allowed to do? Something that Justice Scalia in his majority opinion spends like a paragraph and a half on, which is the whole question. That's the question. What is DC allowed to do is the question. So the other example I'll use Masterpiece Cake Shop as the example.
That's good. A nice simple one.
Yeah, nice and uncomplicated, uncontroversial case about religious discrimination. So Baker wants to he bakes cakes. He bakes very nice cakes. Apparently, in Colorado, same-sex couple would like to get married. They want a cake for their wedding. They come in. He says no. At the time, he says no because of his religious scruples. He's a devout Christian. Colorado has a public accommodations law that says you're supposed to serve all comers. Well, not all comers, but you're not supposed to discriminate on the basis of sexual orientation in particular. The couple sues or brings a complaint to the Colorado Civil Rights Commission. They hold against the baker. He goes to the Supreme Court. Now, this case comes to us sort of psychologically and as a case about a clash between freedom of religion and maybe freedom of speech on one side, speech because he's an artist with his cakes on one side, and equality on the other side. Maybe equality, or maybe just a law that the state wants to pass on the other side. We actually don't, in our constitutional discourse, talk about the rights of the couple as being something of constitutional dimension, as we should.
Ben is nodding. Sorry, I just like
part of the reason we don't do that is because we're afraid of the consequences of doing that. We're afraid that that courts won't actually be able to deal with a case like this if you say that those rights also have constitutional dimension, because we have no language for talking about conflicts of rights. So it's a case about conflicts of rights that we don't talk about as a conflict of rights.
Is international law any better on this, by the way? Just as like a quick question. Maybe it's not a quick question, but we can come back to it if it's a longer answer.
So I think it is. I mean, international law is ineffective for lots of reasons, but not that one, I think. So
okay.
But we can get back to this. There's a lot of comparative law in the book, but not much international law. So problem number one is like Masterpiece Cake Shop doesn't acknowledge conflict of rights, the discourse around it. But maybe even I use it as an example of the way in which the way we frame rights polarizes us. So if you read the briefs in Masterpiece Cake Shop, and especially the amicus briefs in Masterpiece Cake Shop, or read just about any normative article written about the case, like people are basically lining up on one side or the other, and the religious freedom and free speech arguments say things like there's frequent reference to Nazis and Klansmen, and what would you do? Are you going to craft a rule that says if I want a Nazi cake, a baker's got to bake it for me? Okay, so and Alito actually at the oral argument says, what if he wanted a cake that celebrated the anniversary of Kristallnacht? Would you have to bake that cake or not? And on the other side, there were a lot of references to the civil rights movement and whites only signs in restaurants, where the people lining up on the side of the couple said this is just the same thing as putting a whites only sign. And the court ran with that. Justice Breyer and Justice Kagan both said this is, this seems like it's just like Heart of Atlanta Motel or Piggy Park or Ollie's Barbecue. So the problem with that frame is that it actually doesn't even describe the facts of the case. And this is something that is not obvious unless you read very, very carefully and stop listening to people arguing about the case and actually look at what the claims were, because the baker actually did not claim he had a right to discriminate against same-sex couples. In fact, he said he doesn't have that right. He said he can't discriminate on the basis of sexual orientation. And the couple said, look, if you disagree ideologically with what someone wants on their cake, he doesn't have to bake it, right? You actually have a right to not do business in that way. So what were they arguing about? What they were arguing about is whether him providing a cake to this same-sex wedding qualified as discrimination on the basis of sexual orientation, or whether it qualified as discrimination on the basis of ideology. That's an interesting question. I think it's a difficult question, but it's a much more narrow question than do we believe in equality or do we believe in religious freedom? And that's what we should be arguing about. That's the problem we should be trying to solve. Is there a way of solving? How do we address that problem? Well, what kinds of questions would you want to know to address that question? Well, how about asking, instead of is one side a set of Nazis and the other side a set of segregationists? How about we ask, would you be willing to provide this cake if it were baked by your sous chef? Now, he didn't have a sous chef, but maybe you require one, right?
I want to pose is this a rights discourse critique, or is this a Supreme Court manipulates the facts to pose the question the simplistic question that it wants to address, rather than it resolving the question before it, which is a dispute between two parties kind of critique?
But can I tag on to that? Which
Yeah.
is I was going to add, is this what is the question that the Supreme Court is asking petitioners to brief on issue? So to tail into Ben said, versus are these some of the sexier reductionist arguments that get printed in the media, and what the case becomes about because of interest groups and other things? I don't know.
So so I'm gonna weasel out of that and say it's both those things. I think that the way that our tendency to frame disputes like the dispute in Masterpiece Cake Shop in these kinds of parade of horribles, slippery slope hypothetical ways is part and parcel of a way in which our rights culture has been socialized into thinking about rights as essentially a binary question of whether you have the right or not, rather than thinking that inherent within the conflict is a question of application, and that's really the question for courts. Now, there is a discourse that Ben was referring to of we should be solving one case at a time. We should not be making grand statements. We should make sure that people properly have standing, and there's a kind of like Fed courts, Fed jurisdiction kind of set of questions that get asked in cases, and we do occasionally, I think there is some overlap between that discourse and what I'm interested in, but when you look across the whole set of examples, and I gave you campaign finance and religious freedom versus sexual orientation discrimination, but I could give you affirmative action, I could give you abortion, I could give you disparate impact, I could give you social and economic rights, I could give you campus speech, I could give you guns, I could give you public health. And in all of those instances, I can describe to you ways in which our law has been distorted by the fact that we understand rights in essentially binary terms.
I thought you were going to make a joke about the Commerce Clause. Just kidding. Sorry.
Well, that's the next book. Is
okay.
How this filters into the Commerce Clause, I guess.
Ben, go ahead. Sorry.
Well, actually, here's your Commerce. But go ahead, Ben.
Okay.
I can tell you.
So the other question that I like is what you're arguing, that we should have more rights that are less absolute, and so when confronted by the Masterpiece Cake Shop case, we should have a vocabulary that says, okay, wait a minute. First of all, the same-sex couples equality rights is of constitutional magnitude rather than simply a function of, was it Colorado state law, and so we're in sort of balancing rights, conflict of rights territory. Ditto the Citizens United example. Rather than saying one side has a right, the other side is the state with some power, or is the argument that we've merely absolutized certain rights and we're forcing everything into the sort of, either there's a First Amendment right, in which case it's, absent strict scrutiny, it's going to be absolute against power. Is it that we're absolutizing rights, or is it that we're not acknowledging enough of them going on at the same time?
Great question.
So I think those are flip sides of the same problem, right? If you say that, if your frame makes you believe that rights must be understood in absolute or near absolute terms, then you can't have very many of them. Because they are going to constantly come into conflict otherwise. So you see examples, in fact, when we talk about social and economic rights, or we talk about disparate impact, where the court actually just says that outright. It says that in Roe too, by the way, when it comes to the rights of the fetus. That if we acknowledge that this is a right, then we've got to strike down every law, because it's in the nature of a right to go around striking down laws. And so therefore we can't recognize it. Must be therefore be the case that there is no such right. There is no right to disparate impact because we have to strike down the tax laws or the criminal justice system. Court says that explicitly in Washington versus Davis and in McCleskey versus Kemp. There must be no right to education because by the same logic, there be a right to food and shelter and health, and there can't be a right to those things because our system would collapse if there were such a right. We can't constitutionalize the value of fetal life because that would mean that the woman's case collapses, which is there's a whole chapter on this. Absolutely not the case, and that wasn't the case in Germany, which is going through a similar issue from an opposite perspective and recognizing the value of fetal life as something of constitutional significance and women's autonomy and forcing both sides of that dispute to take both of those things seriously.
But it seems to me what you're saying here is, I say this not in any sense as a criticism to our many Canadian Greek chorus members. You're describing the Canadian Charter of Rights and Freedoms, where, there's recognizably a lot of the same instincts, but all with a balancing grain that we don't have. And so, from a Canadian perspective, U.S. law seems on the rights front rigid and absolutist, and from a U.S. perspective, Canadian law seems wishy-washy on everything that's fundamental and important. Are you basically saying we should be more Canadian?
So I'll push back on that only slightly. So there are some Canadian cases talked about in the book. I do generally prefer Canadian constitutional law's approach to rights to the U.S. approach to rights, but I'm not. And so I think the basic question of should we be more like Canada, I would say yes to that question. That's not to say that Canada is necessarily the right model. I think that when you have a certain kind of constitution, which our constitution understands rights in fairly vague, fairly abstract terms, when you have a certain kind of constitution and you're in a pluralistic society, that your only sustainable option is to approach rights in the way that I'm urging. And I think Canadians have generally tried to do that, and Americans have generally not tried to do that. But that's not to say that the Canadian approach is above any criticism. The other thing I'll say is you use the term balancing, and in a crude sense, that's right, in that we're paying attention to both sides of a dispute about rights. We care about both sides. We're trying to show respect for the claims made on either side of a dispute. And sometimes there's a third side, which is the government. Government could be government litigant sometimes. But I don't quite mean, one side says, equality, the other side says liberty, and we're going to put them on a scale and kind of have a Solomonic approach that splits them down the middle. It's not necessarily down the middle, right? It depends on the facts. It depends on the degree of burden. It depends on the alternatives available to the government. So I am talking about proportionality, which is what Canadians would recognize in their constitutional law. But proportionality is not the same thing as just like, a little bit of this, a little bit of that. It's asking questions about the degree to which certain burdens are necessary or not. And sometimes they're necessary because you're vindicating some other right or interest that's really important. How much evidence do you have? Are you acting in good faith? Right? These are questions that courts do answer in some contexts, and they should answer it in this context as well.
So I want to so the mental model that I'm kind of building from what I'm hearing from you is that you have this belief that there should be more rights, in part because you think that like right now we're shoehorning too much absolute, is too much factually into like the limited rights that we have. And so like maybe a recognition of more rights would be better. And then also that within those rights, kind of more dispute resolution, more type of dealing with the fine-grained nature of these things, rather than turning them into overly simplistic binary decisions.
When we bring decisions to courts, right, they've got to make a decision or a set of decisions. The kinds of questions that they should be asking are not, and here's the prescriptive part, are not, is there a right to do X? Our Constitution isn't structured in a way that enables us to answer that question as to most things. We should be asking questions about benefits and burdens and alternatives and evidence. Those are the kinds of questions we should be asking. If we ask those kinds of questions, that entails skipping over or conceding the first question, right? The question of, is there a right? Sure, right? Equality can be understood in very broad terms. Substantive due process, as it's been understood, can be understood in very broad terms. Freedom of speech can be understood in very broad terms. Those questions are not interesting questions, right? The interesting questions are the second set of questions. And so if we understand ourselves to be asking those questions, then we may, in a functional sense, say to ourselves, yeah, there's lots of rights, but that's not the question. The other reason to think about rights in broader terms, though, is because it has to do with polarization. It has to do with how people identify with their rights claims, right? If you tell someone you don't have this right, you lose because you don't have a right, because the Constitution doesn't protect the interest that you think is vital. That's going to alienate you. That's going to polarize you because the stakes of the conflict become existential rather than being about some particular set of facts. And you're going to load all your weight you're going to eventually recognize that you have to load all of your political weight onto who are these judges, because I want them to choose my rights rather than yours. So I think this is a very destructive way of doing what is ultimately politics, which is the art of disagreement and trying to figure out how to get along.
So I'm going to channel Justice Scalia because he's not here, and if he were, he would hate your thesis with the fire of 1,000 burning suns. And
is that like a blur? Are you blurbing Jamal's book for him, Ben?
No, I'm stating a fact.
The fire of 1,000 burning suns. Await Justice Scalia.
your principal antagonist would be Justice Scalia, and I think what he would say is, hang on a second, what you're saying might be fine if it were 1787 and we were writing a constitution, but it's not 1787 and we're not. We have a constitution, and it was a constitution that declares a few rights in it, and then we attached a Bill of Rights too, and we added a few more later on, and they use words like Congress shall make no law, and they use words like, they say things like that Congress, that states cannot interfere, prevent people from voting based on previous conditions of servitude. They have these very absolute languages. They said you can't kill somebody without due process, right? And they don't talk in these balancing terms. They announce rights, and they don't announce other rights. They don't say the same-sex couple has a right to a cake from a private cake shop, though we might write that right today. And so isn't what you're doing is you're diminishing the rights that the Constitution actually protects by its terms to sort of advisory, balancing to courts that, actually take an oath to protect those rights and don't take an oath to protect all the other rights that we might actually take seriously if we were writing the thing from scratch.
So I think that is the objection he would raise, the criticism he would raise. I think he's quite wrong about that.
Okay, so walk us through it. If I were Scalia and I had just made that criticism, first of all, I would have done it in a much more bombastic and asshole-ish form. Secondly, it would have been wittier, and it would have been done in a weirdly affectionate way that it would make it awkward for you to respond forcefully, because it somehow would have seemed like he was saying something nice, even though he was being an asshole. But all of that would have happened. What would the response be?
So a few things. So one, let's start with Congress shall make no law, which is not how anyone understands the First Amendment, right? So First Amendment applies to states, right? States aren't Congress. It also applies to the president, also applies to judges. It doesn't say states shall make no law abridging the freedom of speech. That's something that's interpreted, right? We have to interpret the document. That's point one. Second, we don't really mean Congress shall make no law. If we mean speech in its broadest interpretive sense, Congress can make your decision. If I say, I think we should kill this person, and here's the plan, right? That can be used as evidence against me in a criminal conspiracy. No one would doubt that, right? So we can't really mean Congress shall make. If Congress makes a law saying you shall not, if you're an air traffic controller, you shall not give false coordinates to pilots. That law doesn't violate the First Amendment. No one thinks that violates the First Amendment. So we've got to talk about balancing in any event. And of course, when you get into campaign finance and you get into commercial speech and you get into people using money to fund speech in various ways, and you get into not the state criminalizing speech, but the state providing, here's shout out to Kate, a platform for speech. Where you're talking about a university. Universities have students and they teach them, right? They can't speak indiscriminately in class, right? So we can't. There'd be chaos, right? So that's one thing. We're always balancing, and so it begs the question to say that courts may not balance in one instance, but may in others. The second point I'll make is just about the framers themselves, who very clearly did not understand rights in the absolutist ways that Justice Scalia ascribes to them. And certainly not, I think they did believe that they thought rights were very important, but the way you protect rights in their understanding is you have self-government. And that's what the Bill of Rights is primarily about. It's about juries, it's about local legislatures, it's about the militia, it's about churches, it's about local political institutions.
The first major judicial interpretations of the First Amendment aren't until the 20th century.
Yes, that's right.
We managed to do just fine without courts making a fetish of the First Amendment prior to that.
And so much of the First Amendment is precisely to prevent outsiders, and the Bill of Rights, to prevent outsiders to the community from upsetting the political judgments that community has made. And that includes federal judges, right? Those are also outsiders to the community in various ways. First Amendment, Fourth Amendment, Eighth Amendment are also in part about federal judges. I don't want to fully recover that. I want to partly recover that because I do think rights and self-government have to be hand in hand in a constitutional democracy. But the question is, how do you then bring in an actual pluralistic community into that understanding of rights? Because the framers didn't get that right. They got that egregiously wrong. And so that's the challenge. And so you get Civil War, you get the post-Civil War amendments, which are trying to bring a particular community into self-government, and that's ignored after Reconstruction in favor of various corporate interests. And then the reconciliation after the New Deal is we're going to have two categories, right? We're going to have the category of like super strong, very important rights because we recognize that the U.S. South is a pathological, abusive government, but for most part, so ordinary social and economic legislation, most legislation, you don't get rights. You don't have rights to contract, rights to those sorts of things. But then you get the 60s and the 70s when there's a rights explosion, and the kinds of claims that people are making are not like just ordinary social and economic legislation. So if you're claiming a right to use birth control or a right to terminate a pregnancy or the right to, or an affirmative action case, right? Well, that's not the same thing as a pathological, abusive government that's trying to deny you all citizenship. But that's also not the same as like ordinary, like you're going against a minimum wage law, right? It might be something deeply personal or deeply significant. So and that's most rights claims, right? The big middle ground between your what lawyers would call rational basis review and the strictest of scrutiny. But we deal with those in very bespoke, ad hoc ways rather than understanding that that's the core of rights disputes.
So there's, before I let Kate go to questions, there's a dispute, like one of the ideas I think you're playing with here is this change over the course of, I don't know, between the 30s and the 50s, where the court really goes from a business dispute court that occasionally touches government powers vis-a-vis businesses to an individual rights court. And, I've heard that criticism made in the context of, sort of legalizing a whole lot of rights that were previously kind of resolved by political dispute. But you're also suggesting that one of the consequences of that is the distortion of the cases themselves.
Yes. You've got some if you've got a binary.
But isn't that implicit in your idea but isn't that implicit in what you just said about the middle ground of all rights cases end up everything that gets litigated is in the middle ground, right?
Well, not everything, but
not everything. Sorry,
that's
things to make its way to the court.
That's the main that's the main case is right. Is someone thinks something's really important. They might have very good reason to think it's really important, and the government is trying to govern. Maybe it has some blind spots. Maybe it's ham-handed. Maybe it's overshooting. Maybe it's not. But those are the interesting questions that we need to focus on. If you've got a binary frame and you've got lots of people making kind of reasonable claims about rights, you can either just decide that like all those things aren't really rights, right? That's basically the early Scalia frame, right? Which is it's not explicitly in the Constitution. The framers didn't recognize it's not a right, and that's Hugo Black in the 1950s and 1960s. Or you can be kind of Canadian, right? And say, well, we'll recognize all these things, but let's get into the facts. And I'm urging something closer to that. But in the US, that's the specter of Lochner hangs over that approach, right? So you get accused of Lochnerizing because we've got this Lochner baggage from the early 20th century. And so what's the third option? If you're not going to be a total minimalist and you're not going to be a proportionality, the third option is you're going to be categorical. You're going to try to figure out what are the things that fit into the category of super strong right and what are the things that don't. And we're still doing that. And we're doing that even though like what's in the category no longer aligns with anyone's sense of justice. Like there's a right to pornography, but not a right to health. Like because anyone thinks there's some moral reason for that or because the framers would have thought, so. No, none of that. It's just because we've decided to categorize one of those things into an interpretation of the First Amendment, even though it doesn't say anything about that. And we haven't done that with health, even though it's trivially easy to make a constitutional interpretive argument that extends to the right to health, right? Yeah. So, and part of it is the politics of it, right? And different judges are going to align in different ways, but part of it is not having a language of moderation. We can't say there's a right to health because it'll destroy destroy capitalism or something. And that's obviously absurd.
Yeah. So I have two quick points before we go to questions. But one is that I think I told you about this class before that I took when I was in law school. It was with Michael Seidman at Georgetown. And so to
Here's
those
the
who don't know,
minimalist.
yes, Michael Seidman it was known as one of the crits at Georgetown. He is a critical legal scholar, and he taught this fascinating class. It was like 24 people, and we were all split into 4-person or 6-person courts. And we had the 14th Amendment, and we had to decide which rights to incorporate to the states and under which provisions of the 14th Amendment. And then we would write an opinion, or you would dissent, and then you had to be consistent throughout the course with like the fact patterns that he gave you, the cases that he gave you. And one of the first ones, and I will just like never forget this, was a right to housing. And trying to figure out whether or not you were going to like create a right to housing in like in anything that was in like, the Bill of Rights or anything that was in the 14th Amendment. And, but then trying to argue in a rights-based approach that we were all kind of trained in, like, why wasn't there a right to housing? Like, there didn't seem to be a good reason why this wasn't like, and like, there was, so it was, this was it was one of those classes that was absolutely like phenomenal. And I like learned so much. But the other, were you going to say something?
I'm going to interrupt you very briefly to say everyone believes there's a right to housing. Because if the government showed up and dispossessed you of your house for no reason, everyone would say that's unconstitutional, even though it's not in the text of the Constitution.
Yes, no, exactly.
Or in the original understanding.
And this was like kind of as like little dumb law students, we wandered our way around this kind of problem. But like that's precise. Yes, exactly. Like it's in this, and it's maybe not in the Bill of Rights, but there are these other types of things. But it was a fascinating class. So just kind of pointing you to that because I just think it was a wonderful exercise. And then the other thing that I was going to make a joke about was that I always bring up when I teach my my intro to First Amendment, just like really briefly, and like my internet law class, which is the story of Walter Sobchak in The Big Lebowski when he's pounding his fist on the table of like the diner, screaming at the woman when she asked him to keep her voice down, like the Supreme Court has roundly rejected prior restraint, like you cannot like silence me, and like the dude being like, this is not a First Amendment issue, Walter. This is not a First Amendment issue. And this seems to me for some reason, that little moment of cinema always hits me as like this perfect example of like a rights-based culture, of like this really like this, you're citing to Supreme Court doctrine on prior restraint, but you've just got it all wrong. Like there's no government that's like telling you not to stop. It's just, a waitress in a diner trying to tell you to be quiet. But it's just this ethos around freedom of expression. Yeah, I don't know. I think I have to, obviously I'm looking forward to reading your book, but there does seem to, is it oversimplistic to say that there is like an element of this that you feel like you're making a pitch that like rights have gone on steroids, or the use of like talking about rights is like been just overused by people that are arguing before the court?
If you think that a right is a trump in a political conversation, you're going to frame your position as a right. And so we can approach that reality by saying, so let's just make sure we get them correct, right? We'll ask Madison what he thought and we'll get them correct. Or we can not think of them as trumps and try to encourage people to work out their political conflicts politically. Now, judges have a role to play there. They can say, look, there are limits to how far the government can go, and there are limits to how far an individual right can extend. But within those broad limits, and our job is to figure out if you've crossed those limits or not. But we're not gonna say something's a trump. you both got something. You both have something to bring to this political conversation. Therefore, you both have leverage within this political conversation. Now get to it and agree. You know, sit with that waitress and work it out. Don't claim a right. We're not going to help you. Help yourself.
Yep. Ev, go ahead. It's all you.
So, but first of all, I'm coming from a Canadian background, so my question may be tainted by that. But I was wondering if you believe that there are some circumstances where Congress it would be reasonable for Congress to make some laws to prohibit free speech.
Well,
if you could.
So I think Congress. So I guess I want to know more about what we mean by prohibit. Right? There's a very broad spectrum from criminalizing someone for saying something you disagree with on the one end, to making a funding decision or giving someone a platform or something where the consequences, where you have a scarce resource and you're just deciding who gets to use that scarce resource, let's say. And and what counts as speech also is a broad spectrum, right? From both in terms of, like, is it substantive political speech? Is it just shouting obscenities somewhere? Does it take the form of communication, or is it some other symbolic speech? Right? There are a lot of different axes along which we can understand speech. So the question of, can Congress prohibit speech? Well, I want to know more about what they're trying to do. What is their objective? What kind of speech are we talking about? What is the consequence of this speech being limited? Because we do allow, I'll go back to my, air traffic controller example. We let Congress make laws that restrict the ways in which people can communicate. And we could not have a society if we didn't do that. Congress and states, by the way, which are most of the lawmakers. And so yes, is the answer. Are there circumstances? Yes, but asked at that level of generality is I think doesn't get us very, very far towards resolving actual constitutional questions. You need to know a lot more than is it a law, and is someone's speech being limited in some way?
Daniel, the floor is yours.
So I suppose I have a question that more relates to popular discourse than what's going on in the courts, but I just would be interested in your sense of the rise of the talk about privileges and how you would distinguish privileges and rights, and whether you think there's been slippage going on between privileges and rights at the level of popular discourse.
So I think I would say, no, I'm not concerned with that. In part because, one can ask a kind of ontological question about what is the nature of a right. You can get into the philosophy of rights and ask sort of moral theoretical questions about what's a right and what's a privilege. I'm not interested in those questions. I have thoughts about them, I guess, but I'm a lawyer. I'm interested in governments using the power of the state to coerce people into doing something or other. And when they do that, I would like them to do it in ways that encourage us to get along with each other, rather than doing it in what my dear friend Reva Siegel would call jurisπathic ways, right? Ways that kind of crush people.
That's a great Reva line. How have I never heard that before?
And she borrows it from Robert Cover, so it's really Robert Cover's line.
Got it.
And so the law should leave open the possibility of disagreement between people. So I'm not interested in, and this is part of the problem that I'm trying to diagnose, right? Is that if courts understand themselves as making some kind of threshold determination, is this a right, or is this something else? Well, if the Constitution were very, very explicit, if you had every right was listed, all 4,000 rights you have are listed, and they tell you what's a right and what isn't, then okay, maybe I can stomach courts doing that. But I can't stomach courts doing that with our Constitution, which doesn't do anything like that. Yeah, we can have a conversation about what's a right and a privilege, what's a privilege, but the Constitution doesn't draw any firm lines between that. And I worry about the consequence of giving judges the power to do that when it comes to our political disputes.
No, it's such a smart point, and I think that it's a nice reminder too, because I think that we get so bogged down in kind of some of these discussions, as kind of as Daniel mentioned, that we forget that that isn't something that's reflected in the text. Frank, how are you? It's been a while. Nice to see you.
I know the Crowdcast was kicked me off for about a week. I couldn't get in, but now I'm back. So it's great to see you all and to be back in the chat and that kind of stuff. My question may be as much for Ben as for Jamal. Please forgive me. I lost the specific point that Ben was talking about when he said, we've done so fine, back in the 19th century on free speech rights. And, I'm not sure the 19th century was really perfectly great on free speech rights and compared to the situation now that we're talking about now. And so I really just kind of wanted a little bit more of a conversation about the history there. I mean, because I'm sure there were lots of problems in the 19th century that Ben was, in making a case, not paying close attention to at that moment, although, a more fuller answer, I would just love to hear.
No, your point is well taken. So first of all, my point was not that the 19th century enforcement of free speech rights was exemplary. My point was that we had 120 years of the First Amendment before the chief mechanism of its enforcement came to be judicial. And that is something that's pretty actually hard to fathom now, because if a government does something that you don't like on First Amendment grounds, the lawsuit gets filed the day the thing goes into effect a lot of the time. And so we've gone from, a society that enforced the First Amendment. If you think about the Alien and Sedition Acts, the mechanism by which the opponents of it opposed it was was resolutions by state legislatures, and then when they took power, they repealed it. And so, look, my argument is not that was the better way to do it. I am not an opponent of our First Amendment jurisprudence, merely that it is not inevitable that you protect First Amendment rights judicially rather than by other means. The more contemporary example of that is the Second Amendment, which, until Heller, which is 2008, 2007, is in force. The Second Amendment is a very vibrant right in the United States for more than 200 years, despite having no essential history of judicial enforcement until conservatives decided it's really important to get a authoritative decision on the book, and that gives rise to Heller. But why did the Second Amendment work if you believe in Second Amendment rights prior to Heller? And the answer is because it lived in the hearts and minds of millions of gun owners around the country, and they elected people who did not overregulate guns because they believed in the Second Amendment. And that, I think, is a more contemporary example of rights, even constitutional rights, that have enforcement mechanisms other than the Supreme Court.
Can I just dovetail on Frank's question, Jamal? And one of the questions that I had with the title of the book was which was basically how rights went wrong, but also when rights went wrong. And if you had a kind of a statement on that, but maybe that might be different depending on which rights you're talking about.
Yeah, I mean, I think I want to make sure, and this is consistent with Frank's point. I don't. The book should not be understood as being nostalgic for some time in the past where we did this all correctly. I think we are not where we need to be yet, because I support, the modern First Amendment is a creature of the post-middle of the 20th century, and really the 1960s and on. So, the canonical precedents like New York Times versus Sullivan, for example, these are 1960s cases. Heckler's veto cases or 1960s cases, and so I think that those are good developments in the sense that the court is recognizing something that is a legitimate interest, that it's perfectly coherent to describe and reasonable to describe in rights terms. That's not the same thing as saying that it's that everything you can associate in some way with freedom of speech or with the Second Amendment or with any constitutional right is, presumptively just a trump on anything else. I think whether it is a trump depends on some things about what the government is up to and what the government is trying to accomplish. And that's the language we need to kind of get back to. But I don't think we're there. I think we're not there yet. We just haven't integrated this idea that there are rights and lots of people have them, and that the reason we disagree so often is not because some of us are originalists or something and have it right, and others are not and have it wrong, or vice versa. We disagree because we're different people and we have different commitments and we're a pluralistic community. And when you become genuinely pluralistic, you're going to disagree about rights, and you're going to disagree because it is reasonable for people who are very different from each other to have different values and commitments from one another. So how do you keep those people together in a single constitutional democracy? Maybe you can't, right? So not just not nostalgic, but maybe not even optimistic. But if you can, the pathway to doing that can't possibly be, we'll empower these, judges to decide who's right and who's wrong about the rights that we have. It's got to be a framing and a language of reconciliation, and indeed mediation is the word I use in the book, which is judges should more often, even at the appellate level, should more often think of themselves as mediators than as declarers of rights.
It's so interesting. There seems like there's just tons in this book that I'm going to get something out of, but I love that last little bit because in particular, I don't know if I've ever mentioned this to you, but my mom was a New York State Supreme Court judge, and she was the trial level, and she mostly did torts, and she would just she just very much treated her job as one of mediation. She had a huge number of settlements, just very much encouraged parties to talk to each other and would be the one brokering deals between the parties and trying to understand kind of where they were getting to. And that's really how she described her job. And I feel like that is not how most judges I know think about the work that they do or anything about kind of how, and that's, of course, that's at the state level. It's a very different type of court and everything else. And it's trial court. And it's an interesting case to be made for federal courts as well. So,
well, we think of the Constitution as this grand thing that sets out our rights, and judges must majestically, heroically figure out what it means for all, and we've delegated to judges that role. When I think the Constitution should be understood as ordinary law, which is ordinary law that's pretty vague, and it sets some boundaries, but ultimately it's interested in something you might call constitutional justice, which is that it's got some principles. Those principles are important. The only way to honor them, because they will come into conflict, the only way to honor them is to dig in, and we don't dig in. We abstract out.
We're gonna leave it there, Jamal Greene. You, as Ben would say, I should come up with my own catchphrase and not just steal Ben's. But Ben would say, "You're a great American," but I'm gonna add, "You're probably a great Canadian." since you seem to be so fond of the Canadians today. Thank you so much for joining us. The book, again, I just put it in the chat, is How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. And Ben, wait, hold on. I can do the sign up. We will be back 22 hours and 53 minutes from now with, hold on, who's our guest? Who's our guest?
Our guest, appearing in his capacity as Kate's former politics professor at Brown University, will be Darrell West, who is also my boss at the Brookings Institution, so he can lord it over both of us.
He doesn't remember me.
And that'll be 22 hours and 53 minutes from now. And by then, we will actually have to the Greek chorus results that are useful to interpret from the Israeli elections, which we don't have right now. And don't let those exit polls convince you of very much, except that it's close, which we knew anyway. And so if you remember what Natan said the other day, don't get focused on who has the most seats, and don't get focused on those exit polls. So we'll wait till tomorrow. We can talk a little bit about the Israeli elections tomorrow. Until then, we don't have fun anymore, and we have too few rights taken too seriously.
Yeah. Oh, that's a good way to sum it up. Yeah, I like that. Bye, everyone.